Good evening, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. I want to thank everybody for joining us. Yes, it is Tuesday night. That's our normal going live time. Tuesday night, 6 p.m. Mountain Time. We're usually here, unless I'm in trial. That's right. Your lovable host here at Crime Talk has a day job, that's right, of being a practicing criminal defense attorney, kind of unlike a lot of those other YouTube attorneys out there, all right? Not disparaging any of them, but hey, we actually represent the people on the cases that you talk about. Sometimes not always great people. Sometimes they're fine people that just happen to make a poor life decision. But yes, we actually do what we talk about. So thanks for joining us. For those who have not joined us before, my name is Scott Reich. I am a practicing criminal defense attorney going on 29 years. Can you believe that? 29 years. Been in private practice now for 25. Well, I take that back. 24, going on 25. And prior to that, I was a judge advocate in the United States Marine Corps. So I got the privilege of doing prosecution and defense, primarily defense as a defense counsel in the Marine Corps. Great experience, both as a prosecutor and defense. Some of the best times you've ever had for sure. So what is it? I don't know, 5 years ago, maybe 6, we started this little program when somebody suggested, hey, you should talk about that guy up in Weld County, Colorado, Chris Watts. Remember that guy's name? Yep. Started doing a little podcast, and next thing you know, it took off. And here we are. Like I said, 5-6 years later now, 262,000 subscribers here, 450 on Facebook. Plus, we've got Twitter, Roku. What else we got? Twitter, Roku. I think that's it. Oh, Rumble. Rumble. We got Rumble as well. And and Twitch as well. And just the other day, we went over 2 million podcast downloads, off your favorite podcasting apps. So when I say subscribe if you haven't, like if you do, leave me a comment, and make sure you hit that little bell for notifications. And remember, you can always listen to us on any of your favorite podcasting apps. I'm saying that for a reason. We can be found just about everywhere. All right. So, like I said, it is Tuesday night live. What are we going to talk about? Well, we've got a lot to talk about. First of all, it's no longer April 15th. We can briefly talk about that. Okay. I don't know about you. I don't think I've ever got a refund back. I don't know, probably for the last 20 plus years. All I do is write checks to the IRS, and well, I guess it didn't write a check. We electronically transferred it. But let's just say April 15th is always a terrible day. I thought everything was going great. This is great. I haven't heard from my CPA. Things are going to be good. She said it's going to be okay. And wow. Just, ugh. Anyway, it is what it is. You got to pay what you got to pay. But it's never fun. It's never fun. I always look at it as saying, wow, what could we have done for the practice or on Crime Talk to, do better, expand, raises, whatever, these tough times with inflation, whatever. But no, instead we get to send it to the United States government and to the great state of Colorado, who I'm sure will officially and efficiently spend it, looking out for maximizing all of our tax dollars. And don't get me wrong, I'm not so naive to think, oh, Scott paid taxes. He, no, I mean, my taxes are so insignificant. It probably doesn't even cover just a few seconds of the national debt. But hey, we're not going to go there. All right. So it's April 16th. Thank God the 15th is over, but we'll move on. We'll start working again, try to start saving up because, when the government cometh, they taketh always. So there you go. So we have lots of things to talk about, though. All right. First, the Daybell trial. We're not going to spend a lot of time on this. Probably talk about the first segment here. I don't know. What are we on officially? I think day 4 of the Chad Daybell trial. And all right. Now I said this before, and I'm going to say it again. Let me know if you agree. Now, we can do a show of hands. Okay. Also, we don't beg for super chats, but I will tell you, if you do send a super chat, not going to change my day one way or the other, but it does help your chat get highlighted so that we can see it and make sure that we answer your question. All right. So I said this early on. Some people don't like Mr. Pryor, who is Chad Daybell's attorney. And for those who don't know, Chad Daybell is charged with conspiring with his now wife, Lori Vallow, to kill her children, JJ and Tylee, as well as killing Chad Daybell's now deceased wife, Tammy. And for those who don't know, Lori Vallow went to trial last year. She was promptly convicted by a jury of her peers of all counts and got 3 multiple life sentences. And now she's down in Arizona looking to face additional charges for the conspiracy as it relates to the death of Charles Vallow. Okay. I have said this once and I will say it again. The attorneys for Ms. Vallow, in my opinion, were not good. I know they're death penalty qualified. Oh my gosh, they're so great. Whatever. Okay. They may be death penalty qualified, which is basically grovel. Okay. Please don't kill my client. Please don't kill my client. Please don't kill my client. What can I do to make sure please don't kill my client? And a lot of death penalty attorneys are the type that if we got the death penalty thrown out, we've won. Our client should be so grateful. Everyone should be thanking us. We saved our client's life. I'm a little more aggressive than that. I still think even if you're going for, the death penalty, even if you get it thrown out, you're going in there to win. Okay. That's the way it should be. I don't think Lori Vallow's attorneys were great. Humble opinion. Take it the way whatever way you want. I just thought they weren't very aggressive. I think there was so much stuff they could have worked with, even though I didn't have all the discovery. I was like just dying there, like, listening to it, like, oh my gosh, I could do better than this. And I could just pick it up and go. And then there's John Pryor. And I said, going way back, like 3.5 years ago at the preliminary hearing, remember, Pryor was the only one that went to preliminary hearing on the original charges, and then they got indicted, what have you. But the point is that Pryor actually did a very good job. And I was like, you may not like him, ladies and gentlemen. Hey, I get it. Not everybody likes me. But I'm going to go in there and do my best, and I'm going to make sure that I get what I want, and which is, as much information as possible at a preliminary hearing. And obviously, you go into every trial thinking you're going to win it. Even if everybody around you tells you have no way of winning this trial, a good defense attorney, he checks himself into the penthouse suite of the Psychosis Hotel, and he's like, oh, we can win this. Sure. They may have DNA. They may have a confession. They may have eyewitnesses. Is that all they've got? Oh, I can take them down. So that's the way it is. And it is kind of funny today. There was a little point where they're going to have a hearing as it relates to whether Rob Wood should be able to be called as a witness for the defense as it relates to certain emails that were sent by him and his office to, God, why can't I remember her name? Geez, why can't I ever do that? Not Woods. What's her name? Frank? The one that was there the night the kids died and they were doing their little thing. Gosh, why can't I think? Melanie Gibbs. Gibbs. Thank you. I saw her name. CCNSD came in. Melanie came in and saved me. Melanie, is it Melanie Blake? Yeah. Melanie Gibbs. Yeah, Melanie Gibbs. Anyway, so Wood's office had 300 emails with Melanie Gibbs. And the defense is like, hey, I just want to let you know, all those emails that have been turned over, I'm probably going to impeach Melanie Gibb for that. So, of course, the prosecution wants to have it. And the judge asks, and who will be arguing this motion for the prosecution? And the prosecutor raised, Your Honor, I will be arguing for the prosecution. And Mr. Pryor chimes in. He goes, and I will be arguing it for the defense, Your Honor. And the little chuckle by everybody, like, oh, okay. Because remember, he's only doing this all by himself. Okay. Now, I'm telling you, to do a 10-week trial, from what I can tell, not a whole lot of support staff, 10-week trial, death penalty, solo. Okay. You're either crazy or you've got this. Okay. Right now, I think John Pryor has actually done pretty darn well. Is he any knockout punches? No, but I think he's doing all right. So, show of hands, who thinks he's doing all right? Probably better than expected. I know some people don't like this. He's demeaning. No, I think he's doing a good job. All right. And you can agree with me or disagree, but let's show. Okay, go ahead. Hands up. Okay, I see him. Let me count them. 1. Yeah. There you go. He's doing all right. Okay. Now, do I think he's going to carry the day and, Chad Daybell is going to get acquitted? I don't think I'd go that far. Okay. But he's doing what he can, working with what he has to work with. I think you could say, at least thus far, he appears to be prepared. And frankly, comparing him to Lori Vallow's attorneys, I think he's doing great. Seriously, I think he's doing great. Michelle, MD, better than expected, but still guilty. Hey, I said he's doing a good job. I didn't say he was going to get Chad Daybell acquitted. All right. So let's just be fair there. So yeah, that was the motions hearing. They're going to do the hearing, I think tomorrow. I can't do this lunch or whatever, but Miss Melanie Gibb is supposed to testify. And there are 342 emails and texts between Mr. Wood, the prosecutor, and Melanie Gibbs regarding the case that he may be asked to ask questions about those communications. Now, obviously, it's in writing, right? Classic impeachment type of information. Well, isn't it true, Ms. Gibb, that you said this to the prosecutor, but you said this at a different time? I don't recall that. Your Honor, may I approach? And they go and they say, I hold in my hands an email dated whatever date. And it looks like you wrote in here, did you do that? Yes. And was the nature of that in response in regards to question Mr. Woods? Well, I guess it was. I didn't remember that. Okay. So now what if she says, I completely don't remember? She can impeach him. In theory, he should be able to call Miss Woods as the witness, or Mr. Woods as an attorney, to impeach her. Now, I don't think they're actually going to do that. Mr. Pryor says it's not a big deal, but the prosecutor, Lindsay Blake, who will be arguing for the prosecution, I think she's argued just about everything. Basically, the whole issue of that they can call a prosecutor in a case. Obviously, the case law say it's disfavored, but it can be done. At that point, if there was and this is the thing that as an attorney, whether you're a prosecutor, defense attorney, or, doing civil work, you always try to avoid making yourself a witness in the case that you are doing. Why do you think when defense attorneys go with their investigator or the investigator sent out, does that mean the attorney can't interview those witnesses? No, he may be sitting there right there taking notes, but so is that investigator. The investigator's taking notes. So if that witness gets on the stand, everybody's interviewed the particular witness, and that witness has always said AAA, and then they get to court and they're like, come to think of it, it wasn't AAA, it was BBCD. And then you can bring in your investigator, say, were you you have to lay the proper foundation to impeach them, to say, okay, witness, do you recall a conversation on blank date where, the defense counsel and my investigator and I came to talk with you? In fact, we were sitting in your living room and it was a very nice day and you seemed to be here. You offered us Arnold Palmer's all around, right? Yes, I do remember that. And do you recall being asked the question about blank and you said AAA, but today you said BBCD, right? I don't really recall that. Okay. You've laid the appropriate foundation for impeachment. And then you bring your investigator up to say, yes, this is what was said. Now, if you didn't have the investigator there, you're stuck, right? So if it's just me, I'm there talking to witness, they say AAA, they get on the witness stand, BBBCD, and that's their, well, do you recall having that conversation with me? I was at your house. You offered me a lemonade. We were talking and you said, AAA. Nope, don't remember that. Are you sure? Are you really positive? Because I was there and you were there. But guess what? Now I'm an attorney. So one of the things that the prosecutors and defense counsel are always worried about is not becoming a witness. So you usually take a witness with you. Okay. I don't care if, hey, have your assistant come in, listen to this phone call with me. Hey, got you on speakerphone. My assistant's here. What have you got to say? Take it down, because you don't want to become a witness in that particular case. And so prosecutors have to worry about the same thing as well. And, those communications to that witness are not protected. What should have really taken place in a case like that is you should not be communicating via text message with a witness in the case. A little too familiar, in my opinion. And you should avoid that. The prosecutor, if it was something about, oh, here's the next court date, or the prosecutor had a question, he should have dialed up the witness on the phone, put it on speakerphone, and had their investigator sitting there writing a results of interview memorandum, so this very issue doesn't come up where the prosecutor could be a potential witness on the case and be called potentially for the defense to impeach a prosecution witness. That could be a little embarrassing. Now, Chad Daybell's attorney, John Pryor, has said he does not intend to call the prosecutor, but he intends to use the documents as it relates to those communications between Ms. Gibb and the prosecutor just for impeachment purposes. But you never know. Things change, and particularly what's taking place. So, fourth day in the Chad Daybell trial, not counting jury selection. This was the day where everybody learned about the emails that Charles Vallow sent to Tammy Daybell's work email, discovering that he had discovered that his wife, Lori Vallow, was having an affair with Chad Daybell. And the detectives went through and read through some of the emails today. Basically, Charles, saying, hey, I'm going to let the people know you need to, this is not cool. And I'm going to contact your wife as well. They went through a lot of the emails. Obviously, the big one that kind of shows it's the money thing, is that Lori Vallow texted Chad Daybell on July 18th in 2019 saying that they got a letter from the insurance company saying that she is no longer the beneficiary of Charles Vallow. Oh, man, we killed him for no reason. Oh, man. And Kay Woodcock would be the beneficiary for that. So, of course, Chad Daybell, oh, I love you. This is terrible, but it's probably another step in bringing down the Gaddingtons, especially Brandon. The whole doomsday type stuff. Anyway, so that was it. And then a couple of weird, creepy emails where Chad is complaining as the other married person in this relationship that he feels like a grown-up version of Harry Potter, that who has to live with the Dudleys in his little space under the stairs. And then every few weeks, he gets to escape and have these amazing adventures with his goddess lover. But then I have to return to my life under the stairs, feeling trapped. Oh, see? Told you what was the defense. Told you this day one, right? Chad Daybell, guy going through midlife crisis, gets his world rocked by, attractive woman. Problem is they're both married. So they go off and have this little affair. Oh, and by the way, at some point, whether it was Lori Vallow and Alex Cox or Lori Vallow, Alex Cox, and Chad Daybell conspire to kill her children and Tammy Daybell, obstacles for them, Lori Vallow and Chad Daybell, to be together. And Alex Cox, the brother of Lori Vallow, is her ultimate little protector. That's right. So it's unclear whether Tammy actually ever saw those emails, but the reality of it is, just like in opening statements, this is a statement about the prosecutors. This was desires for sex, power, and money, right? The sex coming from Lori Vallow, power, got to have all these followers, and the money, obviously getting, life insurance from his wife, maybe getting stuff from Charles Vallow as well, so they can run off and do their thing. Well, it didn't quite work out that way now, did it? No, it did not. So that's the Chad Daybell stuff for the day. Day 4. Remember, we'll bring you the trial every day, gavel to gavel coverage. And I don't think we missed a beat, have we, Frank? Frank gets up and makes sure that everything is set and ready to go. And, we were crushing it. We had the George Kelly trial down there in Arizona. It's got to be getting close to being wrapped up. And then the court's like, oh, we don't have enough bandwidth to stream this. So then they put up a nightly video of it. And obviously, once we get that, we'll put that up. But unbelievable. So another thing, case we want to talk about is Richard Allen. You heard of the guy? The guy that allegedly is the Delphi murderer. He's had a rough go of it, right? What can you say? He's had a little bit of a rough go. He gets, 7 years because the FBI, obviously using all of our tax dollars. I know it's the 16th. Get over it, Scott. Using the tax dollars so efficiently that they forget and they misfile a guy that says, hey, I was there during that time. You betcha. Don't worry about it. I was there. And, has a gun that the government says is responsible, or a round that was found at the scene that had not been fired, but had been cycled through a semi-automatic pistol. And then apparently he allegedly confesses. Now, the defense has had a tough go at it, right? First, the attorneys get kicked off the case. They go to the Indiana Supreme Court. They kind of admonish the judge, and the original attorneys are put back on the case, even though the judge was going to fire him. You got the prosecutor wanting to impose contempt on the defense attorneys for allegedly leaking documents that they didn't leak, but they let an old employee look at something and took some photographs. And of course, the prosecutors, this and that. Now, don't get me wrong. Mr. Allen has got some real problems in this particular case. Okay. Well, what are those problems, Scott? Well, first of all, he's in custody, right? Probable cause has been found. He puts himself in the vicinity of the Monon High Bridge there in Delphi, Indiana, at about the time that the girls were there or found deceased. And they would have been there and then ultimately found deceased the following day, right? Problem number one. Problemo number two. Well, they have the unspent round that matches the gun that was in his house, where he basically says, oh man, yeah, I mean, I'm the only one that's ever had that gun. There's no way anybody else could have it. So if it matches that gun, I mean, I don't know what to tell you, but it's my gun. No one's ever had access to it. Problem right there, right? And then we have the alleged phone call to his wife where he apparently confesses, allegedly. We'll give him that presumption of innocence, obviously, like we do everyone here at Crime Talk. Obviously, before they plead guilty or are found guilty by a jury of their peers, and then they're guilty, right? Presumption of innocence. It's powerful, and everyone should be given it, all right? And so, Mr. Allen, he's got those problems, right? He's got the alleged phone call with his wife saying, I did it. Oh, and then there's some other things that even the defense counsel say are, or could reasonably be considered confessions. And therefore you can't believe him. So what are they trying to do, right? One of the confessions they're trying to say is they violated Mr. Allen's right by violating his Miranda rights because he was not advised of those before he spoke with them. And there's an issue of the tape being deleted. We know already the judge, unless you can show bad faith, which is always very difficult to do, it's probably not going anywhere, bottom line. The judge will more than likely say, I find, we haven't seen the video, but hopefully at a hearing we'll be able to see that and get more details as to what was said. But the reality of it is, if the attorneys are filing a motion to suppress, there's something that's bad on that tape for the defendant. Sometimes you file it just because you file a motion to suppress. Well, there's an issue there, but I kind of like that statement, right? But most of the time it's like, okay, if there's one thing that I have to do so that I can make this case go away, what is it? Okay, yep, my client's own confession, which you would be surprised happens more often than not. Most criminals puke their guts out and confess to anything, or not thinking that they're confessing. They actually are, but they think they're the smartest guy in the room at that particular moment, and they just keep talking. I'm telling you, how many times have I told you all where I've had situations where, that detective came, he tried to talk with me, but I didn't say anything. And being the highly trained and experienced criminal defense attorney that I am, I say, all right, so the detective came to see you and you didn't talk to him, right? Oh, man, I hardly said a word. Okay. So how long did this hardly saying a word talk? Oh, he wasn't there for probably no more than an hour. Oh, really? I thought you didn't say anything. Well, I had to figure out I had to figure out what was going on because I had no idea what was going on. So I had to talk to him, trying to figure out what he knew to see what I knew, knowing that I knew that he knew that I knew that I was there. And the client's like, oh, that makes sense, right? And they're like, well, yeah, maybe I was there, but I didn't do anything. Well, you just admitted one of the elements that you were there. You were there, you moron, you idiot. What are you doing? And, so don't be surprised. Most people confess all over themselves. And I'm like, it's always the defendant's own words that get them in the end. Like I said, I don't know if Mr. Allen is guilty as sin or if he has been wrongfully accused And Odinite's cult group, Abby and Libby were sacrificed in that way, and there were multiple people, and he is being part of the sacrificial lamb thrown in there to make this case, make him the fall guy. I don't know. Okay. The defense, don't get me wrong. Usually the defense is much better. The Odinist thing, that can kind of work. It can kind of work. Unless, of course, your client's confessed, right? It's tough to go about saying my client is innocent when he's saying he confessed, right? So what is the defense going to do? One, try to suppress the statement with the police, saying they violated his Miranda rights. Okay. But guess what? It wasn't done forcefully. So therefore, it can be used as impeachment. So if Mr. Allen gets up and says, I am a poor sacrificial lamb, I have never done anything wrong, I don't know why I'm here. Let me explain all the reasons why that particular firearm, other people had access to it, because I had time to reflect upon it over the last 2 years, right? Prosecution can then use that suppressed statement for impeachment purposes. They can't use it in their case in chief, but they can use it for rebuttal, and they can use it for impeachment purposes if Mr. Allen were to testify in his own defense, assuming they win. I'm going to assume they're going to lose. We say, well, Scott, what if they have a legitimate issue and he wasn't advised of his Miranda rights, right? We've got Judge Francis C. Gull, who has, I don't think, granted a single motion filed by the defense other than their motion to withdraw. And we see how that turned out. And so I wouldn't do it. Okay. Another, highly trained, great experienced attorney tip here. You may have a great motions issue, but it is only as good as the judge that you are in front of. Okay. So if you have a great issue and the judge doesn't get it, doesn't see it, now obviously you have to feed it to them in bite-sized pieces, particularly if they are young and inexperienced and maybe have no criminal experience before they get to the bench. You have to say, Judge, this is what I'm going to do for you here. I'm going to show you, and I'm going to give you the case law that says what the prosecutor and the police did is wrong, and it's going to be okay for you to do this, Judge. You're not going to lose your job. You're following the rule of law. And if the prosecution doesn't like it, they're going to appeal you anyway, Judge, so might as well go for it. Okay, but you have to explain that to them. So the motions is only as good as the judge they're in front of. Now, the other stuff, allegedly, there's some statements made by Mr. Allen as it relates to doing terrible things to small children, young girls, to other inmates. Some sort of spontaneous statement to the Department of Corrections individuals. Okay. Well, you have government, you need, to get something suppressed, you have to have government action, right? Fourth Amendment, unreasonable search and seizure, but it's the state. You have to have a state actor doing it, police officer, something along those lines. Now, a correctional officer could or is a state actor. It doesn't have to necessarily be just law enforcement, a state actor. But if they're just observing and listening to what is being said by Mr. Allen, hey, Mr. Allen should have kept her mouth shut. So what has the defense done and come up with? Well, it's obvious, ladies and gentlemen. First, he had his rights violated. Then he's taken out of a county jail and thrown into a prison where people are usually not sent until they actually have been convicted of a crime. But they did this to Mr. Allen as part of the harassment package. And guess what, ladies and gentlemen? They just about sent him over the edge. He lost his mind. He was in a state of psychosis. Who knows what he was talking about? Because Mr. Allen certainly does not. And therefore, what he said, allegedly, is unreliable. You can't trust it at all, right? So that's the defense approach as it relates to Mr. Allen's alleged statements. Yes, inmates involved, of course. Jailhouse snitches. Oh, geez. Where do you even begin with jailhouse snitches? All right. I have attacked on the witness stand, verbally, jousted with jailhouse snitches. I've represented jailhouse snitches, right? So they're terrible if they're rolling on your client. And hey, if you're, their client, just bring in the truth, just trying to make sure justice is served and that the victims get justice. That's what we're there for. It just depends on who you represent that day. I know you're saying, Scott, why are you telling us all of these trade secrets here of being a lawyer? Okay. That was the reason we started this program, to explain to you what takes place in a courtroom beyond what you hear on the evening news. Hopefully, we try to do that on a daily basis. Okay. And yes, that's one of the cold, hard realities of doing this type of work. You oftentimes literally flip sides. One day you're talking about how unreliable that jailhouse snitch is. The next day you're representing that jailhouse snitch and you're trying to get the best deal you can for your particular client, and he's in there cooperating. It just depends on what's in that client's best interest at that particular time. So we'll have to, see how that plays out. Judge Gull, she is a very, I don't know, what's the word I'm looking for? We've had little to no hearings in this particular case. I think she's going to try to do the entire case on the paper, which means we're not going to set a hearing. However, the judge should have to set an evidentiary hearing on the motion to suppress the statement to the police officer, because the defense has raised that issue. The burden then shifts to the prosecution to prove by clear and convincing evidence that the Miranda rights were not violated. And we go from there. Now you say, what is clear and convincing evidence, Scott? What clear and convincing? I don't think I've heard that before. Well, scales of justice, right? Hold on. Break out Lady Justice demonstrative aid. All right. Dun, da, da. Lady of Justice, right? The scales of justice are right here. And all things being equal, they're equal. And can you see that? Okay. Do I have to turn it? Can you see both of those? I can't tell. Okay. Yeah, you can see them. All right. Got the little scales here, right? Scales of justice right there. So civil court, preponderance of the evidence, just tilts to just a little wee bit, moves the scale, right? More likely than not. Proof beyond a reasonable doubt. Boom. Scales of justice the evidence has to be overwhelming. Well, clear and convincing evidence is somewhere right in between equal scales of justice and proof beyond a reasonable doubt. Okay. So it's a higher standard than preponderance of the evidence, but lower than proof beyond a reasonable doubt. So that's why you have to move those scales, right? And what really gets the scales moving? Oh, let's see if I had it. Oh, man. I used to have these weighted down. But looks like we have lost the scales of justice. All right. I know. One more little pointer tip. Justice is expensive. Injustice costs a hell of a lot more. So I used to have these weighted down. So on one side there was like a nickel, and the other side had like 2 quarters, and tilted the scales of justice. I know, Scott, that is so crass. I can't believe you just said that. Oh my God, Scott. Well, oftentimes it is true. It is true. And in today's world, it is getting more and more difficult because there is so much more information than there ever was. I'm telling you, the simplest little case these days, you got 3 or 4 officers to show up to the same event. Usually it used to be, I read the report. Okay. That took me 20 minutes. You talk to the client. All right. File your motions based upon that. Now you get body cam videos. Like I said, quick example, cops are there for 15 minutes, but I get everybody's body cam for that. So now that 15, 20 minutes of review and discovery turned into an hour and a half. God forbid they have, it's even longer with an interrogation, interview, anything along those lines. Or wait, what about a phone dump? Where do you even begin, ladies and gentlemen? It takes days. Think about all the garbage on your cell phone, right? Having to go through that to see if there's anything in there of some relevance. So we'll see. Clumsy clairvoyance. This case makes me want to stick it to the man. It is an interesting case. My first thought when it came out, I was like, oh, they got their guy. Then you heard, oh, they could have had their guy allegedly if he was really the guy 7 years ago, but they misfiled his witness statement. And I'm not making this up, ladies and gentlemen. The FBI, who needs all of your tax dollars and basically has an unlimited budget, couldn't get their filing correct. And so for 7 years, the case was cold as it related to the Delphi murders. So yeah, it's interesting case indeed. All right. So here's what I want to mention tonight. Okay. As you may know, because I did the unboxing the other night. Oh, what was it? Last week, I guess. Right? My certificate to be admitted to the United States Supreme Court was approved. And we went there, we had a case. We were loosely affiliated, but it got me admitted to the United States Supreme Court. So we're going to take it. All right. And it arrived. And I have always found the Supreme Court cases absolutely fascinating. And you say, well, why, Scott? It's just a bunch of, 9 people that are going to decide what the law is. It is. That's true. And it doesn't mean that they are all knowing. Yes, they are smart. Don't get me wrong. They're all very smart. They all went to the fancy law schools. And like I said, it doesn't mean that they're correct. They're just the last ones to get to decide. And that's really what that one boils down to. But the fact that it is the one, these 9 people are going to decide, the last ones who get to decide, is always interesting. What I always find interesting too is that some of the greatest cases in criminal law have been started by either a pro se defendant or a little old street lawyer out there saying, hey, government, you can't do this to my client. I understand he may not be a great guy. I understand that, but guess what? It's you're violating the law, and the government's violated the law, and that's not what the law means. They're using it for whatever reason that they choose to do so. And so I thought it was interesting, and I want to play a couple of minutes from this because I don't think people realize how a Supreme Court hearing goes. Okay, I'm going to play just a couple minutes of it. But it's not like some guy or woman on a TV, the talking head, that's got to get their point in so that their side is always right. Right? It's a give and take. And the justices challenge, both the Solicitor General in this particular case, as well as the petitioners. And, through that process, right, we talk about cross-examination. I mean, that is the best truth-seeking tool ever created. And the today's world has just, spiraled into like a little toilet of, you must agree with me, or you are a racist person. right? You hate people. Oh, I can't believe you said, oh my God, you're terrible. Cancel them, right? But in court, people don't talk. I think a couple of spots, they're talking, and the justice is like, whoa, let me say something. Let me add something to it. So I think it's very interesting. Okay. And today there was a hearing as it related to 18 United States Code 1512C2. All right. 18 United States Code is the criminal law section of the United States Code. And particularly 1512C was part of the Sarbanes-Oxley Act that was passed as it related to the Enron scandal. Okay. For those who don't remember, the Enron scandal was these guys were energy traders. What was it, like 2008 or something like that? And it was a long time. It was like 20 years ago. And things started going bad at Enron. There were rolling blackouts because of these traders and what have you. And I don't mean traders. I mean traders. They were trading futures and options and things like that as related to oil and gas futures. Anyway, so at the time, the country's going through rolling blackouts, a bunch of shady stuff's going on. And Enron basically goes out of business, files for bankruptcy. Of course, they prosecute all the top guys. Ken Lay gets convicted, but between conviction and sentencing, or maybe it was on appeal, I don't recall exactly. Dude dies up in Aspen, I do believe. You've been convicted of multi-billion-dollar frauds. What do? Let's go on vacation in Aspen. And so he died of a heart attack up there. Anyway, if you die before final judgment is, gone through the appellate process, you win. The government has to dismiss the charges. I think most people don't know that. And so he died an innocent man. Of course, it got a little complicated when they wanted to take all the money that they were going to seize to give, but it didn't quite work out. They reached a deal. But you get the point. So during that time, during Enron, the attorneys for Enron or somebody at the top was saying, hey, what should we do with all these documents? Things don't look so good. Hey, I know. Let's burn them and shred them. Okay. And so they passed this section 1512 that makes it a crime to otherwise obstruct, influence, or impede an official proceeding. So the question is, well, what is the official proceeding? Well, we didn't disrupt the official proceeding. Like if you would have argued today is that he didn't disrupt official proceedings. He destroyed the documents that maybe didn't relate to the official proceedings, right? So it gets kind of weird. So this was for destruction of documents as it related to Sarbanes-Oxley, which is like it regulates what companies have to report to the SEC. Okay. But it's the big one that's being charged in the January 6th hearing. And I'm not going to get into January 6th, all that stuff. I just want to focus on the law itself. So originally, how this case ultimately got to the United States Supreme Court is a guy by the name of Fisher. He was a former police officer, and he went to the January 6th riot, protest, insurrection, peaceful gathering, however way you see it, he goes there. And he engages in some things that aren't so good. He assaults another police officer, not good at all, and makes some very bad statements. And there's always a little quote out there that said, bad facts make bad law. And one of the justices today was like, well, the guy's got like 6 other crimes. Why do you have to have this one in here that, was made for like shredding documents? Doesn't seem to be very fair. Like, why are we doing this? And the reason is that this statute is at issue is the district court judge originally dismissed the charge under this section 1512, basically stating that the provision only applies to evidence tampering that obstructs an official proceedings because it is limited by the previous subsection, section 1512C1, which prohibits tampering with evidence with the intent to impair the object's integrity or availability for use in an official proceeding. Right? There you go. Don't shred the documents. We may need that. That's really what it is. So you have to read the two together. Anyway, the federal appellate courts reverse the Nichols ruling and reinstates the charges against Fisher. And here we are up at the United States Supreme Court. And really the issue was there this evil intent, okay? And normally statutes are supposed to be very specific. There was a case also argued, I believe, just yesterday or 2 days ago at the United States Supreme Court about official corruption. And what is the definition of corruption? When does corruption take place? Well, is it corruption if you ask for the benefit before you get the benefit? Or what if you didn't ask for anything, but you get the benefit, get the contracts, and then you send a nice, gesture over of your appreciation to the good congressman, or that case, I believe it was a mayor who got like a new driveway put in, right? He thought he was just getting a driveway. He got criminally prosecuted. So that is kind of the issue where that takes place. And the justices seemed in that case to want to roll back the law because they're saying when you write these vague statutes that there's too much open to interpretation, right? Statutes are written to be do not speed over do not exceed 55 miles an hour. Don't drive excessively. Well, what is excessively under that definition? Is it over 55? Is it 75? But I'm a race car driver. I got a really good car, drives really fast, right? It basically leaves it open to interpretation for, guess what? The prosecutor to say, well, I mean, we're not going to use it in every case, but we're going to decide to use it in this case. And so, like I said, we're not getting into the political side of it. The point is that how many times have I said it? You don't like the laws that are written. They screw them up. Blame Congress. Blame your local legislators. 99.9% of them are all idiots. They never read this stuff, okay? And so here we are. So let's just take a listen as got a couple of the justices kind of asking these questions. Well, is going into the Congress disrupting? Well, what else is disrupting? If we disrupt the courthouse, somebody makes a protest in the courthouse and we have to delay these proceedings. Should people be prosecuted looking at 20 years of imprisonment under that? And of course, the prosecutor's like, well, no, we're not going to do that. No, we know better. Trust us. And like I said, just the day before, the prosecutors are saying, trust us, we'll use this in the right circumstances, these vague meanings and statutes. And that's really what it comes down to. So let's go ahead and take a listen to this. It's a couple minutes long. We may start. Go ahead and roll it, Frank. This is from the Supreme Court.
By C1. Now, I acknowledge that there would have been... Beyond saying, okay, C1 does some things, and the whole rest of the universe of obstructing, impeding, or influencing is conducted by C2. Is that a fair summary of your view? Yes, but there was a good reason for Congress to do it this way. It traces to the statutory history. I understand that. And I would just say that... if I might. So what does that mean for the breadth of this statute? Would a sit-in that disrupts a trial or access to a federal courthouse qualify? Would a heckler in today's audience qualify, or at the State of the Union address? Would pulling a fire alarm before a vote qualify for 20 years in federal prison? There are multiple elements of the statute that I think might not be satisfied by those hypotheticals, and it relates to the point I was going to make to the Chief Justice about the breadth of this statute. The kind of built-in limitations are the things that I think would potentially suggest that many of those things wouldn't be something the government could charge or prove as 1512c2 beyond a reasonable doubt, would include the fact that the actus reus does require obstruction, which we understand to be a meaningful interference. So that means that if you have some minor disruption or delay or some minimal minimal outburst. We don't think it falls within the act of
my
to begin
outbursts
with.
require the court to reconvene after the proceeding has been brought back into line, or the pulling of the fire alarm, the vote has to be rescheduled, or the protest outside of a courthouse makes it inaccessible for a period of time. Are those all federal felonies subject to 20 years in prison?
So with some of them, it would be necessary to show nexus. So with respect to the protest outside the courthouse, we'd have to show that, yes, they were aiming at the proceeding.
Yeah, they were trying to stop the proceeding.
Yes, and then we'd also have to be able to prove that they acted corruptly, and this sets a stringent mens rea. It's not even just the mere intent to obstruct. We have to show that also, but we have to show that they had corrupt intent in acting in that way.
We went around that tree yesterday.
I know. I heard the argument yesterday, but I guess what I would say is that to the extent that your hypotheticals are pressing on the idea of a peaceful protest, even one that's quite disruptive, it's not clear to me that the government would be able to show that each of those protesters had corrupt intent. So
mostly peaceful protest that actually obstructs and impedes an official proceeding for an indefinite period would not be covered?
Not necessarily. We would just have to have the evidence of intent, and that's a high bar.
They intend to do it, all right.
Yes, if they intend to obstruct and were able to show that they knew that was wrongful conduct with consciousness of wrongdoing, then yes, that's a 1512C2 offense. And
what does corruptly add, in your view?
So corruptly adds the requirement that the defendant's conduct be wrongful and committed with consciousness of wrongdoing. And this traces to the court's decision in Arthur Anderson, where the court said this is a term with deep historical roots, with a settled meaning, and that it connotes not just knowledge of your actions, which is, the intent to obstruct in this case, but further requires that it be done corruptly. And just to give you a more concrete example of how this has played out in the January 6 prosecutions, I'd point to the jury instruction in the Robertson case, which we refer to and quote in part on page 44 of our brief. There, the jury was instructed that in order to show the defendant acted corruptly, the jury had to conclude that he had an unlawful purpose or used unlawful means or both, and that he had consciousness of wrongdoing. So I think that that is an encapsulation of what the jury is asked to decide on top of the mere intent to obstruct.
General, let me give you a specific example, which picks up but provides a little bit more detail with respect to one of the examples that Justice Gorsuch provided. So we've had a number of protests in the courtroom. Let's say that today, while you're arguing or Mr. Green is arguing, 5 people get up, one after the other, and they shout either keep the January 6th insurrectionists in jail or free the January 6th patriots. And as a result of this, our police officers have to remove them forcibly from the courtroom. And let's say we have to it delays the proceeding for 5 minutes. And I know that experienced advocates like you and Mr. Green are not going to be flustered by that, but, in another case, an advocate might lose his or her train of thought and not provide the best argument. So would that be a violation of 1512C2?
I think it would be difficult for the government to prove that.
Why?
At the outset, we don't think that 1512C2 picks up minimal, de minimis, minor interferences. We think that the term obstruct on its face connotes a meaningful interference with the proceeding.
Well, it doesn't say, I'm sorry, C2 does not refer just to obstruct. It says obstructs, influences, or impedes. Impedes is something less than obstructs.
I think that this is a verb phrase where iteration was obviously afoot, and impedes is also thought of as
meaning. You're preaching the plain meaning interpretation of this provision. The plain meaning of impede in Webster's is to interfere with or get in the way of the progress of, to hold up. In the OED, it is to retard in progress or action by putting obstacles in the way. So it doesn't require obstruction. It requires the causing of delay.
And if this
so again, why wouldn't that fall within? Now, you say, well, we're not going to prosecute that. And indeed, for all the protests that have occurred in this court, the Justice Department has not charged any serious offenses, and I don't think any one of those protesters has been sentenced to even 1 day in prison. But Why isn't that a violation of 1512C2?
We read the actus reus more narrowly. Now, perhaps you could look at some of the broader dictionary definitions and adopt a broader understanding of the actus reus. Still, there would be the backstop of needing to prove corrupt intent. I think that's a stringent mens rea.
Well, that's
and then
not
the
a corrupt
concept
intent. It's wrongful. Do you think it's not wrongful?
I could imagine defendants in that scenario suggesting that they thought they had some protected free speech right to protest. They might say that they weren't conscious of the fact that they weren't allowed to make that kind of brief protest in the court. And I think it's in a fundamentally different posture than if they had stormed into this courtroom, overrun the Supreme Court police, required the justices and other participants to flee for their safety, and done so with clear evidence of intent to obstruct.
Absolutely. What happened on January 6th was very, very serious, and I'm not equating this with that. But we need to find out what are the outer reaches of this statute under your interpretation. Let me give you another example. Yesterday, protesters blocked the Golden Gate Bridge in San Francisco and disrupted traffic in San Francisco. What if something similar to that happened all around the Capitol, so that all the bridges from Virginia were blocked, and members from Virginia who needed to appear at a hearing couldn't get there or were delayed in getting there? Would that be a violation of this provision?
It sounds to me like that wouldn't satisfy the proceeding element nor the nexus requirement.
Why would it not satisfy the proceeding? Let's say they want to get to the Capitol to vote.
Well, if we had clear evidence that the purpose of the protesters who had set up the blockage somewhere, some distance away from the court, was because they had a specific proceeding in mind, maybe you have the proceeding, but still the court has required a nexus, and that's been the requirement in cases like Marinello, Aguilar, and Arthur Anderson, where the court has said it does real narrowing work, because you have to show that the natural and probable effect of the action is to obstruct. There has to be a relationship in time, causation, and logic. But Justice Alito, the other thing I would say to this set of concerns is that there are other obstruction provisions, including in 1503, 1505, the tax obstruction statute 7212, that use this exact same formulation that the court has characterized as an omnibus clause and never suggested could be subject to an evidence gloss. So I don't think that, to the extent you have concerns about those hypotheticals, your question about what would happen in this courtroom could be covered by 1503. And interpreting this statute narrowly isn't going to cure that issue.
Let me give you one more example. An attorney is sanctioned under Rule 11 of the Federal Rules of Civil Procedure by filing pleadings, written motions, or other papers for the purpose of causing unnecessary delay or needlessly increasing the cost of litigation. And in a particular case, the judge imposes Rule 11 sanctions and says, this caused a lot of trouble. I can tell you it caused at least 5 work days for me personally, all of this unnecessary paper. And it delayed the progress of this litigation. So I'm imposing Rule 11 sanctions. Why doesn't that fall within your interpretation of this provision?
Congress created a specific safe harbor in 1515C. It's reprinted at page 17A to the appendix of our brief that specifies that advocacy or legal representation that is conducted as part of a proceeding shouldn't be understood as obstruction. So I think Congress was itself trying to draw some lines around participation in a proceeding on the one hand versus external forces that obstruct the proceeding on the other.
But it falls within the language, doesn't it?
What kind of evidence do you typically...
All right. So there you have it. I think that was just very, very interesting today, because it really has to do with overbreadth. Is the statute so overly broad that you don't know what's protected conduct and what is illegal conduct? That is the issue. And the Supreme Court over the years has said, hey, these very vague general statutes that you draft, legislatures, Congress, that basically are open to interpretation, they're unconstitutional. And I don't think, people when pass the law, they say, oh, we're going to make this law unconstitutional, but they try to leave it as vague as possible so that it can be thrown out there with the biggest net to cover all the circumstances that they don't think that they've covered just yet. Okay. That's not the way our legal system is supposed to work. The statute needs to be clearly defined the prohibited conduct and the penalty that is there. It can't be so vague that, well, that's okay for this circumstance, but it's illegal for this circumstance, right? And if the law should be applied equally, everybody should know what is the conduct. So like I said, this is not a situation about, it's anti-January 6th or pro-January 6th. This is simply legal argument. And don't get me wrong, the Solicitor General, Elizabeth Perlogan, who is the Solicitor General for this argument, don't get me wrong, very smart lady, very quick on her feet, knows her argument. But what can she only say when they give the example? Like, okay, you say that people went into the Capitol, they delayed the official proceeding of the counting of the delegates as it relates to the ballot. Justice gives you an example. All right, there's a mass protest. They shut down the bridge. People don't get to court. The justices can't get that. She's like, well, that's just peaceful protest. And so that's the wrong. I mean, I think the language at one point was, so you have mostly a peaceful protest, but when you add the words corruptly, that makes it wrongful. And so, and I say this because I think it's interesting, the legal analysis here, and you always have good lawyering, and those are very smart justices. Don't get me wrong, whether you like those or not, I'm telling you, all of those justices, very, very smart. Okay. You may not like them. You may disagree with their analysis, but they're very smart people and they want to get it right. I do truly believe that they want to try to get it right under the law that's written. And like I said, over the last couple of years, the Supreme Court has very narrowly, like, hey, if you're going to write these statutes that are so overly broad and nobody knows what conduct is prohibited, but we'll know it when we see it, guess what? It's probably going to be found unconstitutional. I don't know. I think it's very odd to me that they would, have a section regarding basically destruction of evidence for SEC investigations under the Sarbanes-Oxley Act. Yes, it is a criminal code, but to use it in a way for the January 6th, I think is kind of a stretch. But you have to remember, a lot of those Enron convictions, they were overturned. And guess who one of the most aggressive who was actually got sanctioned by the courts in a lot of that litigation? Special counsel Jack Smith. He is DOJ's henchman, man. He goes out there and does the dirty work, so to speak, get the conviction, let the appellate courts reverse him. He's probably been reversed at the Supreme Court more than anybody, any particular attorney ever. So we'll just have to wait and see. Like I said, I think it's an interesting argument. I think as a criminal defense attorney, you should be allowed to know what is the wrongful conduct. Don't exceed 55 miles an hour. If you do that, we're going to fine you up to $250. Just a simple example of that. Or don't drive excessively. Well, is that 60, 65? Well, it depends on the officer. Judge, we know what excessive is. Trust us. Oh, well, what if one day they said, well, if you drive a dark blue BMW, we know you're always driving excessively, right? So when there's open to interpretation and the person prosecuting it or enforcing it can say, it fits either way, but it's going to fit my way, then it gets a little tricky, ladies and gentlemen. So that's why I thought that was interesting. I know a little bit of geeky legal stuff, but I think that it is important to talk about. I think so much in today's world as it relates to politics gets in the way of actually reading what the law actually says and why certain things can be done or shouldn't be done. And when people challenge it and say, you can't do that, people get all offended, but they're like, you can't do that. It says you can't do that, right? You got to read the law. You can't just pick the ones you choose and you don't like. So, all right. Anyway, I just want to thank you all for joining us tonight. It was our Tuesday Night Live program. We appreciate you. We know there's lots of other things you could be doing, so thanks for joining us. I hope you enjoyed the show. If you'd like to continue the conversation, please do so. We are going to go to our Patreon show for our Patreon members, and we will be there in about 5 minutes. And yes, look, we found the tilting of the scales of justice. Equal, but, let's put the quarter on it. Oh, tilted the scales of justice, ladies and gentlemen. I know, a little cynical, perhaps, a little cynical. Yes, the scales of justice can be moved by he who has the more financial weight on the scale, the resources, ladies and gentlemen. That's what it comes down to. You tell me money don't matter, we can probably figure something out for you or get a better deal than you wouldn't if it was just, we don't have any resources. We're going to try really, really hard, right? Hate to say it, but somehow that's the way it works. All right. Thanks for watching, everybody. But you know the drill. Subscribe if you haven't. Like if you do. Leave me a comment. Hit that little bell for notifications. And remember, you can listen to us anytime on any of your favorite podcasting apps. We'll see you in just a few minutes at our Patreon show. If you haven't done so, hit the link below and you can join. We'll see you in about 5. Thanks, ladies and gentlemen.